Hi, this is for all of my fellow business owners throughout the state of Florida and even potentially employees in the state of Florida. I'm going to talk to you guys today about the effects that employees and businesses in Florida have with respect to non-competes. Are they legal? Can your employer make you sign one? As an employer, can you force your existing employees to sign one? And what happens if you break it or need to sue somebody for breaking their non-compete against you? So let's jump right into it. My name's Tabitha. I'm a business attorney in the state of Florida, so I help clients with these matters all the time. First things first, let's talk about what is a non-compete agreement. Simply put, it's a contract that's between an employer and an employee, and it prohibits the employee from working for a competitor or starting a competing business, and it's limited to a certain amount of time after you leave your job. A common misconception is that if your non-compete is for, say, 2 years, that it's 2 years from the date you signed it. No, it's 2 years from the date that the termination occurs. So whether that's when you get fired, when you quit, you're laid off, whatever it may be, it's 2 years from that date. So there is a catch though, because not all states allow non-competes. And even those that do allow non-competes, they can vary state to state. So I'm talking to you specifically about Florida. Florida, as I mentioned, does allow non-compete agreements. They will uphold them. They are binding as of today. But there are some important restrictions that employers need to keep in mind. So for starters, non-competes in Florida have to be reasonable in time, geographic scope, and the type of work prohibited. And of course, it has to restrict or protect a legitimate business interest. That's kind of a throwaway. There's so many legitimate business interests out there, such as your customer lists, your procedures, the way you do things internally. Of course, that's going to be unique to your business. Unless you're a franchise that you're following a particular script or formula for operating that business, there's a really good argument and pretty easy argument to make that it's a legitimate business interest. So, with respect to the other three, those employers, you can't just create an agreement that prevents your employee from finding work in your industry altogether. That's not acceptable. It goes against everything that the laws protect, which is the freedom to work. However, you can put some reasonable restrictions on there, right? So a reasonable restriction in duration is usually between 6 months and 2 years. It's going to differ based on the industry that you're in. So, for instance, in technology, that industry is changing left and right all the time. So, a 6 month restriction is actually pretty reasonable because so much changes in 6 months. Now, if you're in a more, let's call it archaic industry, let's say it's a restaurant, you're probably going to be able to extend your non-compete a lot longer than just 6 months because things don't change as rapidly in that industry as they do in others. So again, it is industry specific, but usually as long as you're within the 6 months to 2 year term, then the courts are going to assume that that's reasonable and kind of give you the benefit of the doubt. Now, let's talk geography. With respect to geographic scope, your non-compete has to make sure that it doesn't go outside of where you do business. So, for instance, my law firm is located in Fort Lauderdale, Florida. We do business throughout the state of Florida. Okay, so if theoretically, and lawyers are an exception to non-competes, I'm not going to get into that today, but let's assume that lawyers could have non-competes. If theoretically I wanted to put an entire restriction on the state of Florida, I would have a decent basis for doing so. But if you are a mom and pop cookie shop that's in Pembroke Pines, Florida, and you sell throughout Broward County only, having a non-compete that covers all of Florida, or even let's say from Orlando, Tampa, like Central Florida, all the way down, is probably not going to be deemed reasonable because you don't do business there. So there's no reasonable justification for you restricting your employee from going and opening up a competing cookie shop up there. Now, the type of work prohibited. This is going to be, it can be a little general, depending on if you have a good enough attorney to draft it for you. But typically speaking, it's only going to restrict the employee from what they are doing at your current firm or current company. So, for example, if you have a call center and you have someone who is your operations manager. They're handling your operations, your day to day, they're setting up your formulas, your processes, your procedures, your systems, all of that. Well, that's a very broad position that you can set up and restrict them from going and becoming an operations manager elsewhere. Now, if they wanted to go become an accountant an in-house accountant for another call center, there's a reasonable argument that it's a different type of work. That as long as they're not providing their internal knowledge and they're not sharing procedures and drafting up systems for that new competing company, that there might be a basis. Now, again, you could always get sued for anything because realistically, if you were an operations manager at one call center and you went to work as an in-house CPA at another call center, your previous employer is probably going to be very concerned that you're still sharing confidential information, and you'll likely get hit with a cease and desist. But you never know. You'll see what happens. I don't recommend any kind of risk when it comes to non-competes. So, what happens if you are asked to sign a non-compete? Well, first and foremost, you don't have to sign it. There's no law that requires you to sign a non-compete. However, at the same time, especially if you're an employer, you can withhold employment. If they don't want to sign a non-compete, you don't have to hire them. So it's consideration, which is a legal term for like quid pro quo. You sign my non-compete, I give you a job. That's the way it works. And so if you don't want to sign a non-compete, go find another job somewhere else, or you or an attorney on your behalf, likely an attorney because they'll know the ins and outs and be able to negotiate a little bit better, can negotiate the terms of your non-compete. Just because your employer is giving you a document doesn't mean you have to sign it as is. If they have, let's just say, a 50-mile geographical restriction, you can negotiate it to 10 miles or 5 miles or 15, whatever the case may be. You can get as creative as you want with that non-compete before you sign it. Once you've signed your non-compete, you're a little out of luck because now you have the signed contract. They have no incentive to amend it afterwards. You have all the power on the front end when you have not yet signed that contract. Likewise, employers, if you have an employee that is giving you pushback, or a potential employee even that is giving you pushback, that is where you can get creative. You can do things, whether it's increasing their salary, whether it's giving a signing bonus, whatever it may be, giving an extra PTO day, or giving nothing at all. If that particular position is a dime a dozen, there's no need to really give additional incentive for signing the non-compete. But if it's a highly specialized position and you've been searching for months for the perfect candidate and you found the perfect candidate, well, you may want to incentivize them to sign the non-compete if they give you pushback. Either way, both of you, the employer and employee, should read it very carefully so that you both understand what you're getting yourself into, and talk to an attorney before signing the agreement. Likewise, employers, if that potential employee or existing employee is negotiating and wanting new terms, consult with your attorney before you agree to any of those new terms. Now, employers, I get this question fairly often. Can you ask your existing employees to sign a non-compete? The answer is yes. Okay. I get clients all the time that come to me. They started their business, put all of their investment into the company, and didn't really think about any contracts that they wanted to put in place. Whether maybe they did think about it, but they decided, I'm going to reallocate the funds somewhere else instead of investing in an attorney. Understandable. However, now that you've got the funds and you realize, I have built up a brand, I have built up a legacy, and it's very easy for someone to take what I have built and take what I've taught them as my employee to go create their own company, their own legacy, their own path within this industry. Well, you need to protect yourself, okay? Because it's very, very easy for your employees, especially when you're a small or medium-sized company, it's very easy for employees to get a firsthand account of how you operate your business and then go duplicate it, right? So If you have employees, whether they've been with you a day, a year, 10 years, you can always have them sign a non-compete agreement, even though it's after their hire date. Now, they don't have to sign, but in the state of Florida, again, going back to the consideration, that quid pro quo that I talked about earlier, continued employment is sufficient consideration, meaning it is sufficient quid pro quo for a contract to be valid. So if they want to keep their job, they need to sign the non-compete agreement. Alternatively, again, if you're getting pushed back by an employee, you can always make sure that you incentivize them in some form or fashion. And likewise, employees, you can negotiate. If you want to sign it, you just don't really care about those particular terms, you can negotiate it before you sign. But employers, the bottom line is you should have non-competes, maybe not for every position that your company has. If you have a receptionist, you probably don't need a receptionist to sign a non-compete because they're generally just answering phones, scheduling, things like that, which is pretty much a dime a dozen in any industry, right? But if you have a more specialized position or a position that has access to your customer database, your client files, all of that, that you've worked hard to build, then of course you're probably going to want a non-compete there. So with that being said, make sure that you consult with an attorney to get a non-compete drafted, even if they are an existing employer, an employee relationship that's already in place. So next, let's talk about what happens after you've signed a non-compete and then you get a job with a competitor anyways. Sound familiar? It probably does, because either it's happened to you or you know someone it's happened to. And it's a really tough situation to be in once you find yourself in that spot. Breaking a non-compete can result in severe consequences, meaning you can be sued, the employer that hired you could be sued. You might have to pay back any money that you've received as part of your new employment, or you could be barred from working within that industry for an even longer period of time, right? Because it's what's called tolling. So it pauses the clock. If you have a 2-year non-compete, that period where you are indeed competing in violation of your contract, it pauses that 2-year clock. And your previous employer, when they sue you, they can ask the judge to add on the time from the date of your last employment with them. So it's very important to take non-compete agreements seriously. If you do find yourself in that position, you can always negotiate or attempt to negotiate once you have that new position with a new employer. You should absolutely disclose to your new employer, because if they get hit with a cease and desist and your previous employer says, hey, by the way, I don't know if you knew or not, but that person you just hired has a non-compete with my company, and I will sue you if you continue to employ them. Well, if you didn't tell them, guess what? You're probably getting fired. You're not worth the liability. If you tell them on the front end, they could do a couple things. Either one, they're hiring you knowing that it's violating your non-compete, which doesn't happen too often. Or two, they can structure your position in such a way that it doesn't violate your non-compete, if that's possible. Sometimes it is. Or three, they can hire an attorney on your behalf to negotiate your non-compete termination with your previous employer. Sometimes all that they want, your previous employer wants, is a little bit of money, or to make sure you're not going to disclose certain things. So they may let you go work for a competitor if you renegotiate your non-compete, but you're not allowed to give them customer information. You're not allowed to solicit previous customers, things of that nature. So they kind of restrict your non-compete a little bit more while granting you the access to, and an authorization as well, to go work for a competitor. So to kind of wrap everything up here, if you're an employer in Florida, remember non-competes have to be reasonable in time, geography, and the scope of work, as well as a legitimate business interest. But again, that one's pretty easy to overcome. You can't make them overly restrictive. You can ask in your current existing employees to sign a non-compete if you never had them sign one before. And always make sure that if there's any amendments made to the non-compete during negotiations, you have an attorney review them. because you don't want your non-compete to get kind of thrown out the window if and when they go work for a competitor or create their own competing business. That is something that can happen too. If your non-compete is drafted very poorly, or you pulled it off the internet because you wanted to save costs, more likely than not, it's not going to be a valid non-compete because it's not going to contain the provisions that it needs to in order to stand up in court. If you're an employee, make sure you understand what you're signing, make sure you understand the consequences of breaking your agreement, and make sure if there's anything you want to negotiate, you do so before you sign it. As always, if you have any questions, feel free to contact either our firm to help you through the process or a firm more local to you if you prefer. Thanks so much, and let me know if you have any other questions.